The grand jury was presented with the information today. I won't get into the specifics of when they began their deliberations, but I will say that they started early Monday and concluded sometime before noon. And so they heard everything they needed to hear. We didn't withhold anything from them.
All right, welcome back to the Law and Crime Network's Law and Crime Report. I am your host, Bob Bianchi. That was the Kentucky Attorney General, Daniel Cameron, who has come under considerable fire with respect to the investigation of the Breonna Taylor shooting and death of Breonna Taylor. We have some updates here that are really quite amazing. In all the years of 30 years of doing this, I've never seen anything like it. You may recall that the Attorney General was to take over the case after the local prosecutors refused to move on the police officers. The case was presented to the grand jury, and there was only one police officer that was indicted, and it had nothing to do with Breonna Taylor and her shooting, but rather him wildly shooting into an adjacent apartment. And that caused an uproar. We have a couple of great guests on today that we're going to talk a little bit about some things that we had anticipated previously, but we now know to be true. That is the failure of prosecutors in the Attorney General's office to present charges with respect to Breonna Taylor. Well, now we have an amazing development I have never heard of in my career, where there is at least 3 jurors and others that are filing a petition for, get this, impeachment of the Attorney General. They filed it before the state legislature that actually has an impeachment committee, and they're basically saying for multiple reasons, including the abuse of his professional responsibilities and ethics with regard to the fact that he didn't present charges to the grand jury. They actually argue that he was part of the insurrection movement at the Capitol because of his support with a Republican National District Attorneys Association, Attorney General's Association that he was part of, that wrote that letter and encouraged people to go down to the Capitol, and robocalls that went out from that association asking folks to go down to the Capitol. And he's also accused of using taxpayer money to support that lawsuit that was filed by the Republican Governor Association in order to invalidate absentee ballots in the state of Pennsylvania. And you're from Kentucky? Well, we got 2 great guests to break this down. Some of my favorites. First, we'll go off with Julie Rendelman out of New York City, former Deputy Bureau Chief of the Homicide Unit, tried many high-profile cases. She's a law and crime analyst, does other TV and print networks as well. She has a criminal defense practice now, the law offices, if you can believe it, of Julie Rendelman. What a great name for a firm. And then we have our hashtag 4041, give it to Rossi. That is a reference back to when he was a basketball player and they were shouting in the state championships, give it to Rossi so they can win the game. Former DOJ over 30 years, 1,000 trials, and actually has a room at the Department of Justice, and I've actually seen it. It's called the Gene Rossi War Room, in honor of the prolific trial career. These are great trial lawyers. I always love, both on and off camera and in a personal capacity, speaking with them. I consider them great colleagues and good friends. Guys, let's break into this. Julie, I want to start with you. The unusualness, the grand jury process. We saw that press conference, and part of this petition to have the Attorney General impeached is an argument that he was deceptive to the public. And I remember talking, I think maybe to you and Gene a while ago, that boy, oh boy, if we find out that they did not present charges to the grand jury, or at least move towards whether or not the shooting of Breonna Taylor was appropriate, we were going to hear a whole mess of problems. And typically, the grand jury is the prosecutor's playground. And what I mean by that, they have all the cards, they control the grand jury, but moreover, they're entitled to this level of secrecy where they don't have to reveal information. But we started getting a feeling that this was going to be wobbly, and we found out that it was. And these jurors are actually part of this petition to impeach. Julie, have you ever seen anything like it? And what do you think is going to happen?
I haven't seen anything like it. And I think one of the things that sticks out in my head is what you're talking about is the grand jury is usually a secret proceeding. And this seems to be an anomaly because it doesn't seem to be a secret proceeding. Everyone seems to be talking about, and there's much information that has come out. And, one of the things you just said is true, is it really is the prosecutor's playground. The prosecutor really can decide what evidence to present to the grand jury, and they decide what charges to bring for the jury to determine. The thing that is problematic is when you start to talk to the public and tell the public that you presented certain charges, and then suddenly you find out you didn't. That seems to be quite misleading. And that, I think, is the troublesome part, not as much as what charges are presented, but what we tell the public. If we're misleading the public, then I have a real problem with what's going on in terms of this specific AG.
Yeah, misleading the public is one thing, but Gene, I want you to talk about two things because I know that these are right up your alley. The first thing is what I always called, and I always told my assistant prosecutors, the rule of common sense. Now, in New Jersey, and every state is different, you are required to present to the grand jury information with the cops' actions with respect to a fatality. You're required to do that, and that could be part of criminal justice reform. But the other part I want to talk to you about, because I know you're into politics and you got the Gene Rossi show, which you were kind enough to have me on as a guest the other day on the radio.
You were great.
Thank you. And you were great too. The politics, though, this bothers me, Gene. Having politics infused in legal things is a toxic cocktail, and these are elected officials, attorney generals, and therefore many times may be catering to a court of public opinion or a political view rather than just calling it straight down the line with regard to the law and the facts. Comment on any of that, Gene, because I know that you must be apoplectic about this.
I am apoplectic, even for an Italian. I got to tell you this. When I was a prosecutor, whether it was in the grand jury or in a court of law in front of a judge or a jury, I never let politics affect my decision. And I'm a political guy. I was very involved in politics. Even under the Hatch Act, you can get involved a little bit. But after I retired, I was very involved. And I was talking about this with somebody the other day. But when you enter that room of a prosecutor, the office of a prosecutor, you have to have a lobotomy and take politics out of your brain. And what really bothers me about Dan Cameron, the Attorney General of Kentucky, is, as Julie alluded to, he played politics. He gave the public, he ran his mouth and gave the public the impression that they had presented homicide or manslaughter charges for all three officers. That was a lie, And that's damning that he played politics with the grand jury process. And he took over that case, evidently, because he wanted to take it away from politics. But he injected it into the court, into the grand jury room. Terrible.
Yeah, and guys, I can't emphasize this enough. It's the prosecutor that's in there, not the defense team. And prosecutors have a lot of power as to what a grand jury will or will not do. And usually they want to hide behind that secrecy. But in this particular event, you knew that wasn't going to happen. So if job survival is an instinct you possess, you would want to make sure, if you weren't doing it for the right reasons, that at least you could credibly pass the straight face test and say, I presented it, and the grand jury said no. But it wasn't presented, and that is really disturbing. Let's listen to the attorney, Ben Crump, who represents the family with respect to his viewpoint on what the Attorney General has done in this case.
And we question what evidence did Kentucky Attorney General send to the grand jury?
That's right.
Did he tell them about the probable cause affidavit that had a lie on that affidavit, which was the basis for which the judge signed this no-knock warrant in the first place to allow them to be at Breonna's apartment and bust open her door?
That's right.
Because if he didn't send that, my son, well, what did he argue on Breonna's behalf?
What did he argue?
Did he tell them about the 12 neighbors that Sam Aguilar's office interviewed and recorded that lived in close proximity of Breonna's apartment that all said they did not hear the police knock and announce their presence? Did he let them testify before the grand jury? Did he allow the one neighbor who they keep proclaiming that heard the police knock and announce
Yeah, that one.
testify before the grand jury, even though, Tamika, as I understand, on 2 previous occasions, he declared that he did not hear the police knock and announce.
Wow.
So is this the only person out of her apartment complex did he allow to testify before the grand jury? That doesn't seem fair. That doesn't seem like you're fighting for Breonna. That doesn't seem like you're putting forth evidence for justice for Breonna.
You know, Julie, I got to say, when I came into the head prosecutor's position, I was already a criminal defense attorney, a former assistant prosecutor, but I was also a civil rights litigator. And I knew very well the importance of making sure that the community felt that I's were dotted, T's were crossed. I built relationships with them in the community and said, just give me time to dispassionately go forward with the grand jury with regard to a police-involved fatality. And afterwards, you can come to the press conferences, you can ask questions. I was not afraid to tell them exactly what it was that we did, because I knew, everyone knows, the power of the prosecutor to essentially get what they want in that grand jury proceeding. And you know why you do things like that if you're a competent prosecutor? To avoid exactly what Ben Crump is saying, casting doubt over the proceeding. Julie, talk to me about that. And where do they go from here in order to have a presentation to the grand jury that very well may not indict the police officers in the case? We just don't know. But I believe the community, and even myself as a lawyer, have lost faith in the competency at a minimum of the presentation.
Yeah, I mean, and again, we go back to both what you and Jean had said is, you know, we can't play politics. And so it's not the prosecutor's job to get justice for Breonna Taylor. His job is to present the grand jury with every aspect of the case that would be relevant to their consideration as to whether or not there are individuals that should be held criminally responsible for this specific act. And so, you know, if there are witnesses that are potentially missing that should have been called, then obviously it's going to raise the ire of everyone who's going to say, well, why did you only call that one person that helped the police and you chose not to call the other individuals that didn't help the police? And there might be a valid explanation. Perhaps the reason is that these witnesses indicated that they couldn't have heard because they were too far away to have heard. There might be a reason, but we don't trust that anymore because of, as Jean said, the lie that was already told. Now, there's certain pieces of evidence, i.e. the probable cause affidavit. I'm not so clear that that would come in. The issue is whether or not the officers were involved in the writing and creating of that affidavit or knew that there was lies in it. So I'm not sure that that is as clear as Mr. Crump indicates it would be, but it's for the DA to make a determination as to what the jury should be hearing to make a fair decision about whether or not criminal charges should go forward.
Yeah, and it could be that if they allowed the jurors to look at the actions of the police officers vis-a-vis the death of Breonna Taylor, remember, these police officers were fired upon and returned. One was struck and returned fire. It could very well have been something, like I said before, that could have exonerated the officers. Maybe not, but you do it clean and you do it right. And I can't help but think that this is why, and I know you two disagree with me, but this is why I'm glad I'm saying the last word in my prerogative as a host, and you won't have to be able to retort. We need appointed prosecutors, not elected prosecutors, who are putting into that factor of a clean presentation the court of public opinion and votes, as opposed to necessarily what's the right thing to do. Guys, I love having you on. You're sparky, you're excellent, you're great. We got to take a quick break, but when we come back, Kyle Rittenhouse, if you can believe it, is back in court again for a potential bail violation. We'll be right back.
We are here today for arraignment in this matter on behalf of Mr. Rittenhouse. Mr. Richards, do you acknowledge receipt of a copy of the information?
Your Honor, I would acknowledge receipt of the information, waive the reading of the information. I have went over all the potential penalties with my client. He's aware of them. I've also e-filed a jury demand on count 6 for a 6-person jury and the $36 fee earlier today.
All right, thank you. I assume then at this point, you're going to be entering pleas?
Yes, prepared to enter not guilty pleas to all the charges contained therein.
All right, thank you very much. Not guilty pleas to all counts contained in the information are noted and entered for the record. Matter shall now be counted for further proceedings before the Honorable Bruce E. Schrader presiding. And any and all previously imposed bond conditions and issues of bail have remain in full force and effect. Do you understand that, Mr. Rittenhouse?
Yes, sir.
Okay, so Rittenhouse was a juvenile at the time. He's 18 at this point in time. He was released on a $2 million cash bail that had come in from an outpouring. You know, is hero or villain? That's literally what's happening in this case because of, again, the politics of what's going on there. People are really siding not so much with the law. We know this is legal experts, but rather picking a side that he either supported or didn't support, and then basically saying the law should be molded into whatever their political view is. But that's not the way that's going to work in a courtroom. What you heard there was an arraignment, and there were bail conditions. And part of these bail conditions are that they want to make sure that he's not a danger to himself or a danger to others that will appear in court. He was actually found inside a bar with his mother at the age of 18. In that state, you're allowed to drink if you're with your parent. He had had a couple of drinks. He was spotted doing that. He was taking pictures with individuals in like a celebrity status. 5 of the men that are alleged to be Proud Boys were taking pictures with him, and he was seen flashing white supremacist hand signals, that upside down okay. Gene, I want to go to you first with this. I mean, I always say, and I used to say as a prosecutor, if it weren't for, and I mean no disrespect when I say it, it's just the way I said it, the stupidity of people that are out there, judges wouldn't have jobs, prosecutors wouldn't have jobs, defense lawyers wouldn't have jobs. I mean, here this guy is charged with these very serious offenses that could put him in jail for an extremely long period of time, if not life in prison. And he's hanging out in a bar, taking photographs like he's some sort of fan with this group of people, just not the look you want when you're a defense attorney representing somebody on serious charges like this.
If I'm the defense attorney, I'm going to have 3 glasses of single malt scotch because that's going to be used at trial. Guaranteed that the flashing of his fingers, the photos, the Proud Boys, that he's getting drunk in a bar with his mother. Are you kidding me? I got to say this. I would be a tough judge. When you've been accused of murder, 2 victims killed at your hands allegedly, and you almost killed a 3rd, and you're put on bond, you have the tightest of leashes. And I'm going to yank you and detain you in a New York minute if you do what he's doing, reaching across a counter to get a beer and get drunk at a bar. You're gone. You're going back to jail. So this judge, I guess, gave him a slap on the wrist and was very kind to him. But at trial, this could come back to haunt Mr. Rittenhouse big time.
Yeah, Julie, that's a very interesting point that Gene brings out. First off, as a defense lawyer, you want your client to be pristine with respect to this. It puts on a good image to the court, keeps the client out of jail, which makes it very hard for you to defend them. But what are your thoughts to Gene's point that this information, these pictures, could actually be evidential in his trial against him?
Oh, I couldn't agree more. I mean, I was thinking to myself, usually you hear a judge say, you know, as part of the bail conditions, you're not to associate with any of your co-defendants. It's rare that you actually have to tell someone, please don't associate with bigots and racists. I mean, it's rare, and it's amazing that the judge needed to do that. And it's also a shame that his attorney doesn't have control over him enough to say, do you get how serious this crime is? Do you get that what it appears to be is almost like a lackadaisical humor about the fact that individuals have died, you know, based on you shooting them? I mean, it just seems absolutely preposterous that we're in this stage. But keep in mind, those that are taking those pictures are in many ways proud of what he did. There's a reason why they're taking pictures with him. There's a reason why they show those symbols. And there's a pride in what he did. And he may very well think that it looks good to be hanging out with those individuals. Who knows?
Yeah, Julie, to your point, the judge actually ordered that he is not to be associated with persons or groups known to menace people based upon race or religion. It is an extraordinary condition for a judge to put on. Let's throw to a clip real quick of one of the detectives describing what occurred in Kenosha, Wisconsin on that night.
And with regard to those incidents which occurred on August 25th, 2020, can you describe what happened that evening with regard to the defendant?
Yeah, there was a call at 6226 Sheridan Road, which is a car source business, where shots were fired. Investigation later determined that Joseph Rosenbaum was shot in that parking lot and later determined to be deceased. Then Kyle Rittenhouse was the shooter in that incident. He then fled that scene.
And can you describe what happened after the defendant left the scene of the Rosenbaum shooting?
As he was running northbound, there was a crowd chasing after him. He ends up stumbling in the roadway after being struck in the head. When he's on the ground, a subject attempts to kick him in the head. He then fired 2 rounds in the air towards that subject, missing. Another subject approached him with a skateboard, and another shot was fired. That subject is identified as Anthony Huber. That gunshot subsequently killed him. Excuse me. Another subject approached Kyle, identified as Gage Grosskreutz. They had kind of a moment, at which point Kyle fired 1 time, striking him in the right bicep. Kyle's unable to get up and get away from that scene.
All right, guys, let's put our law and crime defense lawyer hats on, just like we would do in law school. We argue one case on the side of the prosecutor, the other case on the side of the defense. There is a self-defense claim here. And Julie, what I also find interesting is with regard to a lot of these people being charged for these kinds of offenses, including the capital, are using the refrain that we were called out as like citizen soldiers to protect property and to at the request of the president and other elected officials. There is some indication that the cops were did not really respond. We're giving water out to some of these folks. Bringing that all together as a defense lawyer, what are you trying to argue on his behalf, especially given the massive publicity that's occurred in this case? And maybe lastly, Julie, what kind of jury do you look for?
So you're not looking for an impartial jury. You're looking for a jury that has a certain political view, and it's probably not going to be my political view. But I think, let me just start with the self-defense claim. Let me be clear, regardless how I feel about the individuals that Mr. Rittenhouse chooses to associate with, I do believe he has the right to a fair and impartial trial. And so I do think there is potentially evidence of self-defense. Whether or not a jury buys it is a whole other thing. And so, there are parts of the video, and when one of the shooting, at least part of one of the shootings happened, that it is hard to see exactly what is happening. And so obviously there's going to be potentially witnesses that say it happened a certain way and others that say it happened a different way. The one thing that is clear, at least in that initial part, is whether or not the other individual, the person who died, had a weapon. Were they a real danger to Mr. Rittenhouse? We know in at least one of the separate claims that one of the individuals, other than Mr. Rittenhouse, did in fact, at the end of the day, have a gun in his hand. Will that be a basis for self-defense? It very well may be. And so certainly I think that as a trial attorney, I'm going to focus on the potential self-defense claims within those facts, and also, make it clear that it wasn't necessarily his decision to be out there. It was the community who embraced him and wanted him to be out there with his gun guarding the front of these locations because of the dangers that were happening, the rioting that was occurring. And that's what his job was. And so he was simply doing what he was asked to do. And therefore, you have to give him a break.
Gene, let's talk a lot about jury psychology here, because to me, it always comes down to the jury. And I was always very careful in how I pick jurors. As a defense lawyer, I'm going to expect that Julie's arguments she just made will be made by those jurors. Again, the government has the burden of proving this case beyond a reasonable doubt. So they're going to have to disprove really that there's a self-defense claim there, as far as I see it. But also, what about the nullification possibility? Let's talk about jury nullification and explain what that is to our audience, and the idea that they may feel that this teenager was an impressionable kid, was way over his head, and that may have an effect on what the ultimate verdict of the jury is.
Well, you said I had 1,000 trials. I had about 110. And I got to say, I had a few acquittals. One or two were classic jury nullification. Here's jury nullification. The jury goes back into the deliberation room. The facts presented by the government meet all the elements of the jury instructions. Yet, for whatever reason, the jurors decide not to apply the law to the facts, and they basically exonerate the defendant. They nullify the law. That's jury nullification. I don't know if that's going to happen here, but you could possibly have a hung jury depending on a jury whom you pick for the reasons Julie said. Putting my defense attorney hat on, he has, defense attorney here, I'm acting, he does have a possible self-defense argument. Possible. It all depends on what the jury instructions for Wisconsin are for self-defense. But he also has what I call I'm really stupid and malleable defense. He's a very impressionable kid. He drove or got transported himself from Illinois to Wisconsin. He thought he was going to be this big hero protecting private property. He's got his AK-47 or whatever firearm he had. He's an impressionable kid, and he got caught up in the moment. And there was no premeditation. There was no specific intent to take anybody's life. And because he's stupid, because he's malleable, because he is a racist, evidently with this sign as indication, he's very impressionable. Is that an argument that a jury's going to accept? Maybe not. And with that vulnerability in his mindset, when he saw all these people coming towards him, whether armed or unarmed, he thought they were going to kill him. That's the argument I would make.
Well, as defense lawyers, those were great arguments. And as prosecutors, we would have to look at those defense arguments in order to rebut them. And that's why he gave them a gift that after all this, he's in a bar with Proud Boys, allegedly, and flashing a signal which shows no remorse. It'll be an interesting case to watch. Okay, Tacoma, Washington. We got a situation out there with the police. You may have seen the video. If not, you're going to see a breakdown of that case here on the Law and Crime Network, running over an individual and knocking down a number of other people with a police SUV vehicle. We'll talk about it on the other end of the break. All right, welcome back to the Law and Crime Report. I'm your host, Bob Bianchi. Tacoma, Washington, this Saturday at about 6:19, police were receiving 911 calls because there were individuals that were doing donuts and burnouts on the street. The crowd had developed and was watching it, and the police responded. And then a altercation, for lack of a better expression, occurred when individuals had surrounded the vehicle that led to a video recording of the incident. I warn you right now, this recording is disturbing, so if you are not into watching disturbing things, just shut it off for at least a minute or so, and we will be back on the other end. Let's take a look.
Hit those people.
Oh my God. Oh shit. Oh my God. Fuck. Holy fuck. Oh my God.
All right, Julie, let me throw to you first on this. I mean, the argument from the police department, at least as right now, it's under investigation, but they're saying that the officer was in fear of his life, that he was being surrounded by the vehicle and they were pounding on the windows. And therefore, he did what you saw on that video. You saw a number of people were knocked down, and one person was literally under the back wheels of that vehicle getting run over. I won't give you my commentary until I hear what you have to say, Julie, because I'm pretty much anticipating it's going to be what I think.
Yeah, this one, I have mixed feelings, and it reminds me back to, I've had several leaving the scene of an accident cases where a client has either hit a pedestrian and then was the car was surrounded and basically, trying to get in to get him. And so what did he do? He drove off. And so suddenly there was a leaving the scene of the accident claim, and his defense was, well, I can't stay at an accident if I'm going to get killed myself. Now, obviously, police officer is in a different position. He has a weapon. He can call for backup. And I do, I wonder if there's other video that can take us a little closer to see exactly what was happening in terms of whether or not they had weapons, whether they were using just their fists to try to get into the vehicle. You can tell that the vehicle at some point backs up a little bit as though he's trying to get out of the area. But he does seem to move awfully aggressively in terms of when he goes forward. And I'm not sure he needed to do that to get out of the situation. And that's what caused at least one of the individuals to be under the vehicle. And so I think that this is one of those cases that I do want a little more information before I give you my kind of opinion as to what my thoughts are in regards to this.
Yeah, and Gene, I agree with Julie completely. A lot of times you get a video and people jump to conclusions, but we've also seen that we get a paucity of a video in the beginning of a case that looks really bad for the cop. And then as time goes on and after public opinion has formed, the other videos surface that give much more credence as to what the officers were doing. But from an optical point of view, officers, I wonder about the training that's going on here. I don't suggest in my mind at all that this officer got up that day, said, oh, let me go to a place where people are doing drag racing and burning, doing donuts and stuff like that. And if my car gets surrounded, I'll have an opportunity to kill somebody. Nevertheless, to Julie's point, it just seemed to go from, zero to like really hitting the gas and hitting the pedal. There was no doubt about the fact that people were going to get run over, it would seem to me. What are your thoughts about all this?
I agree with Julie that I have mixed feelings, because if he did not exercise proper discretion, he could have turned his lights on. He could have used a foghorn or something to give them a heads up that he's driving away, and then he should drive away slowly. But then you got to see what else was going on around him. Were people yelling, "We're going to kill you"? Were people banging on the door? Did anybody have an object where they were going to break through the window? We don't know what was in the mind of the officer. And this could be a tough case either way. It's not just what you see on that video. There could be more there. And thank goodness people got hurt, but nobody got killed. Thank goodness.
Yeah, it'd be a different situation. And to the point of a legal issue, it's just what the point of a reasonable police officer under those particular circumstances would have felt was the appropriate use of force. We do need more facts, but the optics of it certainly don't look good, and we hopefully can expect a full and fair investigation. Let's switch gears a little bit. These Capitol rioters / insurrectionists / protesters, well, one of them is now charged with threatening to assassinate Representative Ocasio-Cortez. The DOJ has filed new charges against Garrett Miller, saying that there were threats found on social media. And he basically made statements that he was a Trump supporter and that she deserves to die, won't survive long because it's hunting season. These are words he's using. Civil war could start. Next time, bring guns. His lawyer says, however, that he regrets what he did. He did it to support President Trump by misguided hyperbole. Gene, back to the point that we were talking about before. What is it specifically about this, just real quick, that political things being used as a defense? Is it a valid defense at all in cases like this?
No, the First Amendment protects speech that does not incite violence. But once you cross that line, it's not politics, it's not freedom of speech, it's insurrection, it's inciting violence. And these individuals, especially Mr. Garrett, he committed both insurrection, which attacks the authority of a government, and also sedition, which hinders or delays the execution of a law by a government. And on that day, January 6th, they were voting to certify the electoral vote. But here's the thing about Mr. Garrett. He may be in deep hurt because they did a federal criminal complaint, which is just a placeholder. They're probably going to indict him on equal or more serious charges later. And in the meantime, the grand jury subpoenas are flowing from the U.S. Attorney's Office in D.C. and also Main Justice. And they're going to get cell phone data, emails, all kinds of documents and social media posts against not only Mr. Garrett, but other individuals with whom he may have been associating. So this is a very serious charge for him because he and others, to either kidnap and or harm and kill members of Congress, including Vice President Mike Pence. Very serious.
Julie, as prosecutors, though, we have a First Amendment. I want you to talk about this because this seems to be the thing that a lot of people are talking about. And we understand that there's limitations on that First Amendment, but could this be puffery? Or as a prosecutor, don't you want to see a little bit more? People make these kind of accusations against public figures all the time. Or do you feel that this is enough and that the social media companies are right to stop these things from being published because they have, even if it's not the intention of the person, the capacity to drive other people that are not as emotionally stable to do bad things? Where does that First Amendment begin or end with cases like this?
Well, when we're talking about this individual, he did more than just speak. He actually did go and into the building. So I think that there's a little more to this than simply just puffery. And so I do have trouble with also I think his attorney talked about the idea of hyperbole. This is not hyperbole. He was pretty clear of what he wants to do. And he took steps to do it. And so, that distinguishes him from, other acts of people simply venting about their dislike of somebody or saying, they would hope something happens to someone without more. One of the things that also I think is important to note is that there are many individuals that were arrested on that day or shortly thereafter when they were identified for going into the building. He is going to distinguish himself because, at the end of the day, when the feds are making a determination as to who to give a deal to and who not, the individuals that just went in there without, the emails that we expect to find on this individual's, computer, the text messages, the Twitter, they're going to distinguish him in terms of what they think is appropriate sentencing versus an individual that simply went in there just because they were following the crowd.
Yeah, Julie, I agree with that assessment. But Gene, let me play devil's advocate with this. He could have been writing those things about the representative. He could have gone in there, which could be a substantial step in maybe doing that. But still, prosecutors have lodged a charge that his goal, his intention, his purpose was to assassinate a congresswoman. And is it not possible without emails, without text messages showing that it could be he went in there, he was part of a crowd, he had no intention at all of carrying through an actual homicide?
Well, if you're absolutely right. If that's all you have is just him going in, breaking a window, or watching people break a window when he went in and he yelled and screamed in the House and Senate chamber, he still could be guilty of insurrection and sedition. The felony murder rule or Pinkerton, that's another issue. But I will say this, this guy is facing things that he did before. There's a case called Brandenburg versus Ohio, 1960 case. You can run your mouth all you want. You can attack public figures all you want. But when you cross the line and try to incite violence, which Mr. Brandenburg did not do, but if you encourage violence, encourage people to fight, trial by combat, fight like hell, if you encourage that, then you have crossed that line and it's not protected under the First Amendment. And that's probably his problem. He not only spoke bad things, he, as Julie said, he acted on it. That's a double whammy for that guy.
Okay, we're going to leave it to that legal principle of the double whammy. It's very close to the Gene Rossi polenta analogies that we get here every now and again here at the Law and Crime Network. But a Black widow murderer has just been given a reprieve by the Nevada State Supreme Court on a death row conviction, having it reversed. It's a fascinating case. We'll get to it on the other end. All right, welcome back. So this is a little bit of a twisty case here. The Black widow murderer, as this gentleman is referred to, his name is Thomas Randolph. He had 6 wives, 4 of whom wound up dead. He was tried a long time ago for the killing of wife number 2, that's his wife Becky, in 1986, again, found not guilty. The defendant is now 65 years old. He had been convicted of a double murder, a murder of another wife, as well as the hitman that he supposedly hired. Well, the Nevada Supreme Court he's on death row, reviewed this case, and they gave a stunning rebuke of prosecutors in the case, making an argument that this case should be reversed. Let's listen to Anjanette as she gives us an idea of what it is that this case is about. Anjanette Levy from the Law and Crime Network.
This was Thomas Randolph's first time in a Clark County courtroom since being granted a new trial last month. He wore a mask and a long ponytail. He spoke briefly but directly.
I want a speedy trial. I want it done now.
Randolph is accused of murdering his sixth wife, Sharon, at their Las Vegas home in 2008, and then killing the hitman he hired to kill her, Mike Miller. He had been sentenced to death for the killings, but the Nevada Supreme Court ordered a new trial, finding the jury should not have heard testimony about other acts evidence, such as the 1986 death of one of Randolph's wives, Becky, in Utah. Randolph was acquitted in that case.
I think there's some lack of evidence that is more mind-boggling in this entire case than anything else. The prosecution really planted seeds in the Las Vegas jury for Sharon Randolph and Mike Miller that he's a serial killer, but there wasn't a lot of evidence to truly back that up.
Melissa McCarty and Kelly McLear have exclusive interviews with Randolph from death row for their new Killer Genes podcast.
It seems like everybody and their brother wanted to bust me for drugs. That's what the Utah case is about, the drugs and all the women I had sex with. And it's not criminal. It may be not good if you're married, but or they're married, but it's not criminal. The times were different back in the 80s.
Thomas Randolph has an answer for everything. And it's fascinating to hear. And you have to go, do you take it with a grain of salt or are you taking it as truth? And the only people that knows that truth is Thomas Randolph and those that are dead.
Prosecutors have declined comment, but are moving forward with the retrial. Thomas Randolph will be back in court on February 19th with new lawyers, and at that time, the judge could set a trial date. For Law and Crime Daily, I'm Anjanette Levy.
All right, great job, Anjanette. And I love it, Gene Rossi, that she referred to as other act evidence, not prior bad acts, because that drives me crazy like nails on a chalkboard. But nevertheless, Gene, you have heard me go off on so many occasions about this abuse of what we refer to as Rule 404, which is other act evidence that can be used if it's relevant towards motive, opportunity, intent, plan, mistake, rebut a claim or a defense. It has to be very specifically tailored because the general rule is you can't have a trial by character assassination. Gene, you know that story I told you where I was given 5 opportunities to use 404 evidence. I only used 2, and it saved the conviction because the Supreme Court said he did it because it went to motive, but he didn't overdo it. Here's what the Supreme Court said in this particular case. I think it's a rebuke that's beyond, I have not seen in a court opinion. But ultimately, the state lured the jury into finding Randolph guilty based on a myriad of other bad acts that were not even marginally relevant for a non-propensity purpose, rather than constraining the testimony to evidence relevant to the crimes charged. So what do you think, Gene?
I think that New Jersey case that praised you for only using 2 of the 5, as I recall from your story, was spot on. And the old phrase, pigs get fat, hogs get slaughtered. And when prosecutors try to bring in this bucket of other crime evidence, which prosecutors love to do, they're foolish. Sometimes you pray for something hard enough, you're going to get it. They got their gift, but now they have a retrial. That was very stupid on their part to throw in the kitchen sink to muddy them up. And that's the whole purpose of 404B. You have to have a specific reason, motive. And even then, a judge has to do a balancing act to see if it's unduly prejudicial. Because the guys charged for one crime don't bring in all these other crimes to make them look bad.
Right. Julie, we got a limited period of time, but I'm curious about what your thoughts are. This always gets to my point. I've never had a conviction in a homicide case reversed as a prosecutor. You can do this stuff well. You don't have to throw garbage into the case. Why does this continue to happen? Because now the case of the prosecutor is worse. It never gets better on retrial.
Well, it actually may not have been good in the first place, and that might be the reason that they wanted to get this other act evidence in. It does remind me a little bit of the Durst case, because one of the issues that I believe that the court raised when they reversed was that they used this prior murder case in which there was an actual acquittal on it, and so that seemed to raise red flags for them, because the prosecutor's argument was that the murders were so similar.
Got to do it clean, guys. Always love having you on. You guys are awesome experts. You can find me at RBianchi ESQ, and we have regularly scheduled program coming up next. Have a great week.